Have our reporters have sacrificed today so that we could have us maximize our time with the jury. So I am going to give a break to Camilla. And as far as Mr. Durst, I got the sense from Mr. DeGuerin that he would waive his presence for these evident legal rulings.
Yes, before he goes, because I want.
Oh, okay. Does he waive his presence?
Yes.
Okay, I'll accept that. And I'll give you a break. Why don't you come back when you're ready, and we can talk. Mr. Chesnoff, we can talk in the back and chambers.
Great. Yeah. Habib, I think you're essential.
It's Webex meetings or Webex department?
Oh, it's video or what?
Okay, I got it.
Mr. Prosecutor said. Juries don't get transcripts.
All right.
Good afternoon, this is the Clerk and Department One.
Thank you.
Welcome. We'll be with you in a moment.
Thank you.
You're welcome. And thank you for your patience.
Let's see. Do I have a microphone? All right, we are back in session in Department 1. This is a WebEx hearing regarding witness Andrew Jarecki. I recognize Mr. Jarecki, and I know there's counsel for Mr. Jarecki also present. Let's see, who's appearing for the third party, Mr. Jarecki?
I am, Your Honor, Victor Kovner. I'm joined by my colleagues Linda Steinman, Paul Monis, and Dan Laitman, all of whom have appeared before you in one form or another previously. And of course, Mr. Jarecki is on the phone as well.
All right, for the defense, I've excused the defendant under 977B of the Penal Code. At his request, we have Mr. Chesnoff and Mr. Lewis present, representing Mr. Durst. We have Mr. Lewin, Mr. Milius, Mr. Bailey, and Mr. Miata, Mr. Henderson, all representing the people. The context here is a subpoena of witness Andrew Jarecki. Originally, it was thought that it might be possible to avoid his testimony by way of a comprehensive stipulation. And the court accepted that stipulation, which rendered the original moving papers moot. However, now he He is now again called as a witness by the people in rebuttal, which then makes right again these questions of privilege. The moving papers really echo what had been previously litigated in my court pretrial, and that is I am upholding the privilege and immunities of Mr. Jarecki as a journalist. I have done that, and my tentative is to do the same, not by precluding his testimony, by allowing it, but by limiting the scope of examination and cross-examination of Mr. Jarecki. Do you wish, so with that, the moving party is the third party. You wish to be heard, Mr. Kovner?
I do, Your Honor. Very briefly, first of all, I want to express our appreciation for permitting us to participate in this by phone. Our application is a very brief one. It is our understanding from the prosecution that his rebuttal, the testimony of Mr. Jarecki as rebuttal witness will be very brief. It is our understanding that it will take less than 10 minutes. And so we do renew our motion of July 6, seeking only limited relief, namely that the cross-examination be limited to communications as to which Mr. Durst testified on cross, and that in no event it should address, as Your Honor has already suggested, the content and editing of the as-aired version of the jinx, or other unpublished or undisclosed information concerning the sources, news gathering, and editorial processes behind the jinx, nor information concerning the sale, distribution, or licensing of the jinx, nor the promotion of or publicity for the jinx, or personal information about Mr. Jarecki, his finances, or health. Lastly, as set forth in our motion papers, we seek permission to allow Mr. Jarecki's personal counsel, Mr. Monis and Mr. Laidman, who have participated in the July 6 motion, to appear on his behalf and, if necessary, to make objections during his testimony. That's the limit of our application this afternoon, Your Honor, and I'd be happy to answer any questions or set forth the authorities that are basically set forth in our July 6 motion papers.
I think the last request is the easiest. Is there any objection to counsel for Mr. Jarecki appearing in this court?
None, Your Honor.
No.
And that he be permitted to object as appropriate to protect a claim of privilege or immunity?
I trust the court's discretion in allowing that, Your Honor.
No objection?
No objection.
So that part is granted. I'll hear from the parties about this proposal. Do the people have any objection to this proposed limitation?
No, I think we'd rather hear from the defense first regarding, and then we'll respond to.
But you have no objection to what is proposed by Mr. Kovner on behalf of Mr. Jarecki?
No, I don't. I would simply add that I don't know if it'll be 10 minutes. I think it's going to be very, very quick. I think it's on our side. It would certainly, I think, be less than 20 minutes. I don't know what the cross will be, etc. But it's a very limited area. And just so it's clear, on our side, stipulation 70 was originally agreed to by both sides, and the idea was that in lieu of Mr. Jarecki and Mr. Schmerling testifying, we would be entering into that stipulation. As the court likely remembers, at the time, what we said is that subject to only a situation where, as an example, and I think we even covered this, where Mr. Durst says something like, I didn't actually say the things that are on the jinx, etc., that were in the interviews, that we would need to potentially call Mr. Jarecki. Mr. Durst has instead said something that is related, which is, I was given a script, he told me what to say, these were not my actual statements, I got them from Mr. Jarecki. So our intention is to call Mr. Jarecki to do the following, to ask him, Mr. Jarecki, there have been allegations made by Mr. Durst during his testimony that you either gave him a script and/or told him what he was to say. Are those allegations true? And then he would answer, and it's my understanding he will say they are not true. Can you explain, Mr. Jarecki, why those allegations are untrue? And then he would explain them. That would be what we would anticipate doing on direct examination for rebuttal.
All right, and there would be no objection to that sort of questioning. That's what you expect, Mr. Copper, right?
That is correct, Your Honor.
So, who will speak for the defense? All right, and Mr. Lewis? Any objection to my limiting this as I've tentatively done?
Well, Your Honor, with the preface of the email I sent you, there are a few discrete areas.
Oh, I never read it because I'm trying to rule on these objections by Mr. DeGuerin and to these interesting questions by Mr. Lewin, and I never actually took the time to read your email. So forgive me if I ask you to repeat its
Quite all right,
contents.
Your Honor.
I wouldn't have minded if you were a bit distracted during some of those objections.
For the sake of expediency, Your Honor, I will outline the areas that we think are proper inquiries and cross. Mr. Durst should be allowed to confront the witness regarding his motive for testifying, as he is being called by the people and His Honor is acutely aware anytime a witness is called to testify, his motive is at issue and proper subject of cross-examination. In this case, Mr. Jarecki intends to produce a follow-up to the Jinx. We'll call it the Jinx 2 for purposes of this hopefully very brief hearing after the trial concludes. Therefore, he has a clear pecuniary interest in the outcome of this trial. Mr. Durst must be allowed to question him on this subject. 2, Mr. Durst should be allowed to confront the witness regarding the editing of the Jinx. The editing reflects the witness's bias towards Mr. Durst. As this court is again acutely aware, Mr. Durst's comments in the bathroom were edited to increase the inculpatory value of those comments for cinematic purposes. Lastly, Your Honor, Mr. Durst should be allowed to confront the witness regarding the collaborative efforts with law enforcement leading up to Mr. Durst's arrest in this case. Again, these actions illustrate both the motive and bias of the witness. Thus, they are proper areas of inquiry on cross-examination. According to Mr. Lewin's proffer, he will ask Mr. Jarecki to expound upon Mr. Durst's comment regarding, I guess the word script or suggestions regarding certain answers to questions that he would be asked on camera. Thus, we should be allowed to inquire of Mr. Jarecki to the extent of all meetings he had with Mr. Durst, not just those that were recorded, including phone calls as well as those in-person meetings. As Your Honor is painfully aware, these are Mr. Durst's rights under the 6th Amendment to the United States Constitution, the Confrontation Clause specifically.
All right, I got a question for you. Isn't some of this covered by the stipulation itself? In other words, the editing has already been, there's a stipulation about the nature of the editing. As far as what collaboration may or may not have happened, isn't that covered by the stipulation already? And so that's my question.
And to the extent it is covered, Your Honor, if it becomes, in our opinion, relevant to cross-examine, we'd like to be able to do that.
Can you respond briefly, Your Honor?
Yes.
So, I absolutely agree with Mr. Lewis that obviously a witness's bias is always relevant. However, this is an unusual situation. This is not simply where we are electing to call a witness in rebuttal. This is where there was a stipulation regarding that witness's testimony. Mr. Durst has testified in a manner that is inconsistent with the stipulation that both sides entered into. As the court recalls, both sides agreed that when that stipulation was entered, that unless the court decided that there were extremely extenuating circumstances as to why Mr. Jarecki would need to be called, such as what has turned out to occur, that it would not be allowed. So here's the issue. I agree. I understand where Chip, where Mr. Lewis is coming from on what would normally happen with a witness. but this is not a normal witness because of the stipulation. And so what the defense is basically trying to say at this point is, we want to be able to get into a bunch of areas that we had already agreed were not going to be covered by the stipulation we all entered into. And again, the only reason we find ourselves here, Your Honor, is because the defendant, in essence, in violation of the stipulation that was entered, has come in and said that, well, I said those things, but he made me say them, there was a script, etc. Finally, and I think it's absolutely relevant on a related issue, is that under 352, as an example, today I wanted to impeach Mr. Durst with statements that he had made in jail regarding wanting to get a new trial and using COVID to do so. And the court, although very clear on the record that this area was relevant, the court under 352, and I understand, said, hey, listen, just because it's relevant, under these particular circumstances, under 352, I'm not going to allow it. So now let's apply it to the situation here. This is a rebuttal witness coming in for an extremely limited purpose. And in essence, what Mr. Lewis is asking to do is he's asking to treat this witness as if he is being called as a normal witness. And in fact, if he were being called as a normal witness, we would have absolutely no objection to anything that he has discussed that he wanted to bring up, because bias is relevant, with the exception of very likely the relationship between the prosecution and the police, which the court has already ruled upon. But most of the areas of bias that he would like to explore would otherwise be proper. They are not in this circumstance.
May I please see a copy of that stipulation?
Do we have
I have it, I can get it, but
Your Honor, do you want me to email it to you right now? Would that be? I don't have a hard copy.
that's fine. Yeah, but we have it. Oh, we have it. We have
It's
it.
stipulation 70.
Okay, we have it. So, Mr. Kovner, I'll let you weigh in next before I return to Mr. Lewis.
Yes, thank you, Your Honor. Very briefly, as I think Your Honor said in your introductory remarks today, the question of the editing has basically already been ruled on, and I think that's also true as to the alleged collaboration argument. Those were fully discussed in the motions we brought, the two motions we brought before you in 2019, and I think your decisions were quite clear with respect to that. And I would just note, passing, even in one of your comments, you noted that under these circumstances, bias was not pertinent. In any event, the last point, which was the first point made by Mr. Lewis, which related to subsequent, what he called jigs 2, I think Your Honor is well aware, and one, that Mr. Jarecki is a journalist, two, that there are dozens and dozens of journalists who are following this trial, who are writing about it and covering it, and while Mr. Jarecki has no plans to do anything in particular, he has every right to follow events in this trial, and indeed, given the extraordinary research he's done, it's particularly appropriate that he be able to, he hasn't forfeited any of his rights, and so with respect, we stick to our initial request that the cross-examination be limited to whatever is offered on a rebuttal direct, namely the questions that Mr. Durst has provided in his answers during his cross-examination, and no more.
So, but that almost begs the question: how does one impeach a witness who simply contradicts Mr. Durst? Mr. Durst says he has testified essentially that he was given hints or specific directions, whether it was a script or by some other means in conversations that were not reported, that Mr. Jarecki told him to say bad things about himself, to make himself look bad because he wasn't interesting enough, unless he depicted himself as a villain. So the question is presumably, I mean, it's not a particularly credible assertion, but nevertheless, that is what he asserts. So should Mr. Jarecki say, no, I didn't do that, and this is why I didn't do it, and this is why I would never do such a thing, the defense would likely wish to reduce the credibility of Mr. Jarecki. So what is fairly allowed and what is off limits, I guess. And some of it is because clearly there is he's acting as a journalist, and so much of what one might ask is simply off the table. So this idea, first of all, that he might have some motive to lie, that's the first idea, that he would have a motive to lie because he wants to succeed. He has a plan for Jinx 2, which has simply been asserted. I've not heard any evidence of that, but secondly, that the editing is going to be off the table. Collaboration with law enforcement, I think, is resolved. Fourth, all meetings and phone calls. That's interesting because Mr. Durst is talking about. Mr. Durst is making reference to some statements that were not actually recorded, but that's when we're getting into the very heart of what is protected in journalistic privilege. So it is a bit of a dilemma here. Mr. Lewis, I invite you to comment about what could possibly be fair under the circumstances and a reasonable cross-examination.
Your Honor, it is not lost upon the court the nuance that I'm talking about regarding motive. The fact of the matter is that the people are calling Mr. Jarecki. Mr. Jarecki's, the nuance here underlying this is what is the gravamen of my argument. Why is he calling him? He's calling him to support the people's position that these were Bob Durst's free and voluntary answers. He was not coached, suggested, whatever moniker we would like to place on it. Well, with that purpose underlies the nuance that I'm talking about and the need to cross-examine him regarding his motive. His motive is to support the product that he produced. To support the product that he produced, we should be allowed, and the Confrontation Clause mandates, that we be allowed to explore what may color the testimony that people are now calling him for to confirm their position. That is where it lies. The red herring that Mr. Lewin wants to throw up about 352 and what happened to him today is wholly inapplicable here. They are calling Mr. Jarecki. The only reason that we are here, as the people have admitted, is because of Mr. Jarecki's film and what came out of that. I have all the confidence in the world that this court recognizes the need for us to cross-examine Mr. Jarecki on what may shape or color his testimony. And I was trying to be delicate about it, but since Mr. Kovner went there, we might as well get it out. If Mr. Jarecki is not making the Jinx 2, as we have very good faith reason to believe, why in the heck did he have a cameraman trespassing in our hotel trying to film us? And when confronted by Mr. Chesnoff, he had some very enlightening things to say. I invite Mr. Jarecki to speak on it since he's on the wire if he'd like to, but don't tell me we don't know that he's planning the Jinx 2. He said it.
All right, thank you, Mr. Lewis. So whether or not, listen, I don't want to descend into a debate about whether or not there's going to be a Jinx 2 because it doesn't really matter. To the extent that that's his work is journalism, and he's free to explore this without fear that he'll be asked to testify about that. Mr. Chesnoff, you had a notion?
Yeah, I just have a thought. If the concern is about the privilege, then why is he testifying at all about what he did or didn't do with Bob? Either he takes the privilege seriously and doesn't want to talk about what he did with Bob because that is part of the privilege, or he is waiving the privilege by coming here at the direction of the people that he cooperated with, meaning the people of the state of California, to testify against Mr. Durst. If he is being pure about the privilege, then he should not be talking at all about anything he did to make this film. But they are getting to cherry pick what he gets to talk about how he made the film. They bring him in to say, I didn't coach him, but wait a minute, you can't ask me any other questions about how I made this film. That's inconsistent, Your Honor.
That's very interesting. I mean, it is a sort of a one-way process. I mean, the typical cross-examination about something a statement that's a witness will make a statement and the other party doubts it. They say, did you write it down? Did you keep notes of that? Did you document it? And of course, I can't allow those kind of questions, right? Because that's privilege. So perhaps you should have another stipulation about what he would say. I mean, I have to say that the testimony really didn't ring true in the first place. But are the people? And let me add something else. It's not Mr. Durst, I think rather brilliantly, has taken refuge in unavailable witnesses. So he's testifying that he told people about various things that you'd expect him to share with others, and he has referenced lawyers. He's referenced people who are deceased. He has used this strategy, I think, of talking of making claims that he knows cannot be refuted because the evidence would be inadmissible. It's been fascinating to watch that. But that is a good point that Mr. Chesnoff is making, and Mr. Kovner might even be tempted to agree with Mr. Chesnoff on that. So, Mr. Lewin, what do you say?
Well, Your Honor, again, we're ignoring, and the main point of this is not the fact that it's a 352 issue. It's the fact that there is a stipulation that all parties agreed to in advance. We entered in good faith. The good faith that we entered into was that, in fact, we're going to be having this stipulation regarding these interviews. Mr. Durst then gets up, and as the courts, I mean, let's face it, he gets up there and he perjures himself and he says, listen, he told me what to say, I had a script, etc. We have really no choice but to address this. And so now what happens is that Mr. Durst, and I'm going to say Mr. Durst, not the defense team, but Mr. Durst now, having in essence operated yet again in bad faith, is now going to be able to apparently say, hey, I can make this stuff up, and now I can go get the exact same kind of examination that I would have been able to get had there been no stipulation. So the key issue is not 352 in the context of a normal invocation of 352. The key issue here is we had a stipulation where both sides were precluded, absent some exigent circumstance, from being able to call Mr. Jarecki. And it's interesting, what the defense did not do, and I understand it, is they didn't come up here and say, hey, Your Honor, they can't call Andrew Jarecki. That's a violation of the agreement. Because even they understand that Mr. Durst was up there, in essence, saying something completely inconsistent with what his attorneys, and therefore he, stipulated to. So, Your Honor, that's the big issue that Mr. Lewis is not addressing. He is pretending that the same rules would apply, whether there had been a prior stipulation or not. and they simply don't.
So what, so here's the question. You're suggesting that he may testify
Yes.
and not be cross-examined?
No, he can be cross-examined about any area that goes to what in fact he said to Mr. Durst regarding the alleged hints, conversations about hints, script, etc. What he cannot be cross-examined about are all of the other areas that he would have been able to have been cross-examined had both sides not entered into a stipulation. And again, Your Honor, I think it's very important that the court make the finding, as much as the court can make a finding, that, listen, Mr. Durst got up there, and in essence, at the very least, Your Honor, he testified completely inconsistently with the stipulation that was entered. So he is the one who is making us, putting us in the position where we have to go back and bring in Mr. Jarecki to refute this. That should not now allow him to benefit, to get around his stipulation by now saying, oh, it's open season, I want to be able to ask him about all the things that I wanted to ask him about if he had been a witness. If that's what they wanted to do, they didn't need to enter into the stipulation. We are taking this action because Robert Durst got up there and made something up that was inconsistent with the stipulation he entered into. That's why we're here.
All right, if what he testified to is inconsistent with the stipulation or violates the stipulation, keep in mind that anything that is the subject of a stipulation is proved. You tell the jury, this is proved, there is no dispute, these are the facts.
Well,
For him to testify contrary to that stipulation seems like that's its own remedy.
No, here's the problem. It's not directly contrary in the fact that obviously there's only so many things that we could imagine. So had we known this, there would have been a stipulation that in fact the statements from Mr. Durst during the interviews were not the product of Mr. Jarecki or Mr. Smerling.
Your Honor, if I may?
Yes, yes?
Mr. Lewin makes the point, and I'll try to truncate it because I know with all his talent, that's one he doesn't have. He makes the point. He asked these questions of Mr. Durst. Mr. Durst gave an answer. It's not contradicting the stipulation, but let's solve it. You can solve it, Your Honor. Have him read the stipulation. They don't need to call Jarecki. We're done. It's because of Mr. Lewin's question.
No, I mean, that's what I'm
And it's
thinking.
not contradicted by the stipulation, in fairness. It may be contrary to what they were trying to do, but the people drafted this stipulation, Your Honor, and as many phone calls as Mr. Lewin has listened to of Mr. Durst, he knew this was coming. So,
Well,
but you're right, Your Honor. Just make them read the stipulation. That's the answer.
Well, Your Honor, if Mr. Lewis wants to make the assertion that the testimony of Mr. Durst is not inconsistent with the spirit and meaning and intention of the stipulation, I don't think he's going to say that. I'm not going to tell you that, as I sit here right now, that the statement by Mr. Durst is technically inconsistent with the stipulation because it was not specifically added there. It is clear, Your Honor, and the court is aware that obviously neither party at the time the stipulation was made, or the court, I don't think, in any way could have anticipated specifically Mr. Durst is going to get on the stand and say, and Jarecki gave him a script.
Your Honor, may I add something, please?
All right.
Thanks. Your Honor, Mr. Lewin asked hundreds of questions about the jinx after the stipulation was entered. As a result of the questions that Mr. Lewin asked Mr. Durst had a right to respond. He took the witness stand and he had a right to tell his version of events. His version of events was in direct response to repeated questions from Mr. Lewin. As a result, Mr. Lewin does not like the answers he got. So as Mr. Lewis just said, they can either stick to the stip and we're done with Mr. Jarecki, or Mr. Jarecki comes and we get to do what you do with any witness in a U.S. trial to be consistent with the Sixth Amendment, and that is cross-examine Mr. Jarecki about the very things that Mr. Jarecki is going to testify about, what he did. That's why they're calling him.
I'll say, Mr. Lewin, when you probed this, in fact, you even brought up many times, is this one of the things you say Mr. Jarecki told you to say? I mean, I don't know how many times you did it, but it was clear, I think, clear that the assertion that Mr. Jarecki had authored this was ludicrous. I mean, it was absolutely ludicrous that the thought that it wasn't Mr. Durst. You even got him repeating the very same words when you interviewed him. How could it be that even if Mr. Jarecki told him to say these things, why would he say the same thing again to a deputy DA and two homicide detectives? It made no sense. I mean, it was, there's really nothing there. But Mr. Kovner, I am going to turn to you. You represent the witness. What?
Your Honor, as Your Honor has held, these are important privileges that any journalist has, and we've asserted them, and we believe that the assertion of them helped lead to the stipulation, which would have obviated the testimony. And merely because Mr. Durst, in effect, contradicted the thrust of the stipulation as to the genuineness and accurateness of the interviews, that doesn't cause Mr. Jarecki as journalist to have waived his privileges. We assert them, and they are vital, and there is simply no reason, in our view, Your Honor, why the very narrow rebuttal that is proposed by the prosecution should open the door to eliminate all the protections that have been accorded the journalists and by Your Honor in the course of this proceeding. And so we adhere to the view that any cross of Mr. Jarecki should be narrowly circumscribed.
Well, that's sort of one-sided, Mr. Kovner. What about the balance? I mean, what about the right to confrontation? I appreciate your articulating that right, but I appreciate when an advocate can tell me what's more important.
Well, he does have the opportunity to confront Mr. Jarecki regarding the limited testimony he's providing, to ask about the conversations he had as to those matters that where Durst has contradicted him in his cross-examination, and I gather that's been done on a number of occasions. So there are areas where he can confront him and challenge him, but that does not open the door beyond that narrow area. We respectfully submit that would grant him the appropriate confrontation in this context.
So would that include a discussion of private conversations they had that were not filmed? Do you think that's fair game? Conversations in connection with the interviews as to which testimony has been elicited, I think the answer is that would be fair game. He can ask about the conversation he had with Durst. He can ask about whether there were any scripts provided, any documents. We produced an incredible volume of documents, all the documents related to Durst. I don't think they're going to be able to find anything that supports these apparently false assertions by Mr. Durst. But as long as they're limited to the cross-examination testimony by Durst, it seems to me that would be appropriate. Beyond that, all the areas that the defense seeks to go into, it seems to us, is outside the scope of what's permissible here.
Your Honor, very briefly, when you cross-examine a witness, you had the pleasure of doing this very well in your day before you were on the bench. I'm not just going to ask you, did you say it? Did you write it down? Why are you here? What motive do you have? What has colored your testimony while you're testifying? It is relevant every time. We're not violating his reporter's privilege. We're doing what the Confrontation Clause mandates.
And one last thing, Your Honor. They cannot answer the question of why they are selectively enforcing their First Amendment rights to benefit the state at Mr. Durst's prejudice. They are clearly not being purists here, Your Honor. They are saying that it's okay for us to come and testify about what we did when we want to talk about that part, but when you want to talk about what our motivation should be, that's off the table. They can't have it both ways, Your Honor. The pure response should be, he shouldn't be allowed to testify unless he's allowed to be cross-examined.
You have some authority for that, Mr. Chesnoff? Do you have some authority for the idea that a journalist may, if he testifies at all, that there's no limit to the cross-examination?
I'm not asking for no limitations, Your Honor, but I am asking for what Mr. Lewis asked for, which is the right to go into his motivation, what his plans are. Your Honor, I was there when, and the funny part is, Your Honor, I was never going to broach the subject of the trespass at our hotel because I had told Mr. Jarecki as a courtesy I would not broach that, understanding that he was not going to be a witness. But as soon as we found out that they planned on calling him in rebuttal, I contacted his counsel with correspondence to let him know that that was an issue, and they're still marching forward. So what are we supposed to do, Your Honor? Not do our job?
Your Honor, I'd cite the authority of the Constitution of the United States.
Oh, of course. Why didn't I think of that one?
You did, Your Honor.
Yeah.
Your Honor, and again, I think it's very important because counsel is not answering this at all. They are pretending in their analysis that there was no pre-existing stipulation.
You've already said it. It doesn't contradict it.
If I could finish, anybody who believes that Mr. Durst, in his testimony, was testifying consistent with not only what the parties specifically entered into, but with what the meaning of that stipulation was, I don't even think they're going to make that argument. So again, Your Honor, as I said, if we were calling Andrew Jarecki as a witness, most of what they would want to do would be appropriate. You would not see me objecting to it. But it is very limited rebuttal based on in essence, testimony inconsistent with a stipulation that both sides entered into. And obviously, Your Honor, the fact that they are not opposing and saying, Your Honor, they can't call Mr. Jarecki because we have a stipulation. By the fact that they aren't even making that argument, they are conceding that Mr. Durst, in his testimony, testified inconsistently with the meaning of that stipulation. Or else, Your Honor, they'd have a great argument. You can't call him because you agreed that he wasn't going to testify. That's how you got the stipulation.
I want you to call him.
So we can't ignore.
So you're also would move to exclude it.
If we're not going to be able to fully cross-examine him as the Confrontation Clause allows, he should be excluded. But I welcome Mr. Jarecki testifying. I've looked forward to this for months upon months.
Well, that wasn't their attitude when they asked and entered into the
stipulation. There are other reasons,
stipulation.
Mr. Lewin.
Your Honor, it's interesting to me that Mr. Jarecki asserts the privilege when it comes to what he's going to say in an open court in front of a jury, when he has repeatedly met with the people. And I'll read you an email that he sent to Special Agent Perry. Eric, thanks for your call. I'm happy to meet with you and continue our discussions. It will give me some comfort for you to confirm that the FBI and the government won't contend I've waived my journalistic privilege by getting together to discuss matters of mutual interest. I mean, they're picking and choosing all the time, Your Honor.
All right, I got to think about it. Anything else?
No, thank you, Your Honor.
Anything else from people?
No.
See you all tomorrow. I'm going to meditate on this. I will try to rule in the morning, first thing in the morning.
Have a nice evening, Your Honor.
Thank you, Your Honor.
You're welcome.
Are we doing any exhibits today or no?
Yeah, let's see what other things we can talk about. All right, thank you. Goodbye. So I wanted to talk about, you want, I thought we would get out of the way because you did, Mr. Chesnoff, make a motion in limine to preclude the prosecution from arguing that hypotheticals presented to Dr. Loftus were incorrect. So, first of all, is this moot? I mean, with the defendant basically acknowledging that those statements...
Well, I plan on arguing. I plan on making some argument. Sorry. I plan on making some arguments that perhaps what Mr. Durst said on the witness stand is something that he said that they can take, but they can also consider
I see.
Dr. Loftus. So
So you're not withdrawing it?
I'm not, Your Honor, and I would submit it.
Okay, well, I think that I looked carefully at each of your hypotheticals, and I think it is a fair argument, it would be a fair argument that they are misleading. And the fair argument is not because the facts you chose weren't correct, because you were very, very careful to choose facts that were conceded, that were proved, there was a basis for them, but you still chose facts. And I think if the facts that you omitted from your hypotheticals could change the conclusions. And so I don't think it's unfair if the people choose to argue that it is misleading. But third of all, and the third point, and this is a tentative, third point is that none of your authorities that you cite support such an order from me, ordering them not to argue that the hypotheticals are misleading.
Okay, and my response to this would be that they had an opportunity on cross-examination to supply the facts that they believed were misleading to Dr. Loftus, and of course they didn't, because they spent most of their, a couple of times maybe, but most of the time talking about her and her credibility. But I understand the court's ruling, and I'm fine with it. Thank you.
Okay, and now, how about defense exhibits? Your own exhibits, you wish to move them into evidence, don't you?
Yes, please.
Is there any objection to the defense exhibits?
Kim has a list. Mr. Henderson has a list.
Mr. Tim Henderson, last but not least, today. Defense exhibit.
Photo, blank calendar, 2 pages of people, 146. Deed, check. Lost CD. Portions of
And these are copies of, separate and apart from the ones that weren't trying to get about people.
John.
These are defense letter exhibits.
Okay.
John.
Yeah.
John, when did you what's the basis for that? As evidence, we need to do that.
That doesn't come in.
No, it's hearsay.
Absolutely. It does not come in.
There's an objection to one exhibit?
Well, they're going through it now. Your Honor.
I believe,
Email to Tom Bevel, did you say?
yes.
That's hearsay?
Yep.
There was testimony about it.
There's testimony about it.
Does not mean.
No, right.
There's
Okay, that
testimony.
doesn't mean, you don't talk about something that's not authentic or, nobody agrees there's a foundation, that doesn't admit it.
No.
Yeah.
About CB.
I believe he
I don't
admitted.
care if her CD comes, that's fine.
He admitted it? I admitted it?
What's
No,
that?
no, the witness admitted that it was genuine. He just argued about what it meant.
Wait, what is?
The
Yeah,
email.
okay, so it's not the authenticity of the document, it's whether it is hearsay, right?
Well, it was his words. He was there to be cross-examined about it. It's not hearsay, it's to him. It was the witness's email to Mr. Lewin.
It is hearsay. It's not a court statement admitted for the truth of the matter asserted. It's classic hearsay.
Right. It doesn't matter if he's a witness. It doesn't necessarily mean it's not hearsay. There's
It was
the difference between
cross-examination.
confrontation and hearsay. Confrontation is satisfied if the witness is on the witness stand and he can be questioned.
But doesn't it have some indicia of reliability under an exception, Your Honor, the catch-all, because he authenticated his own words?
I'm sorry, the catch-all. I don't know that one.
I'm sorry, Your Honor.
I don't know that one. You can move to. I'm gonna sustain the objection. You can move to reconsider.
There's a
If you-
federal one, that's
If
what.
you have authority, you can give me authority for that. Okay. Anything else? Everything else okay?
Well, hold on. Going through, hold on.
While they're looking at it, I'll just put on the record that the conditional examinations were not admitted as evidence, but they must be available for appellate review. So the edited conditional examinations are lodged. They're not given to the jury as exhibits. If the jurors have questions, it can be read to them. Also, the original conditional examinations are already part of the record because of the statute that allows and authorizes conditional examinations.
And we would also ask, Your Honor, that the transcripts of, the edited transcripts of the portions of the conditional witnesses that were played be lodged as part of the record also, so that's available to an appellate court.
Yes,
Thank you.
yes, we'll do.
And also
we'll do
for
that.
argument.
That's for all conditional exams that were presented, correct, Your Honor?
Correct, yes. All conditional examinations, whether presented or not, are part of the court's record.
No other
as to-
objection. No other objections, Your Honor.
Okay,
Okay, no other objections. All defense exhibits will be received with the exception of E.
and just to clarify, Your Honor,
Yes.
I'm not sure that they put all of the conditional witnesses that were played on their list. If that's not accurate, I've been informed that. Is that true?
All conditional examinations are either lodged, and the edited transcripts also are lodged. Everything is lodged.
So the ones that aren't on y'all's list are going back to the jury?
No.
None of them go to the jury.
None of them are going to the jury room?
Right.
Correct.
But they can still be, I think this is the
It
question.
can be read to
Yeah,
them.
the jury wants, okay.
They can, and we have no objection,
Okay.
if they want to, for closing argument, if they want to use part of the transcript that was, because it was not admitted, but the actual edited testimony that was played, they can use that. They can use the video, anything that was,
Of course.
that came before, you can use. The jury just doesn't get it.
And, Your Honor,
But
just to-
in argument, the jury has seen this stuff, and we can
Yes.
use what the jury has seen during the trial. right?
Perhaps, I mean, if there are exhibits that I excluded, I mean, if you had just because it was in the courtroom, if I sustain an objection to its admission, it can't then be shown to the jury anyway. That's the point of the objection, is so that the jury will not see it. Only the things that are admitted are shown to the jury.
Well, but let me see if I can understand this. In my cross-examination of Mr. Bevel, I showed the jury on the screen, his email to Mr. Lewin. Now, so there's no question about authenticity. It's his email to Mr. Lewin. There's no question about confrontation because he was there to be rehabilitated in our cross-examination.
Confrontation is your right, not the people's right. You're talking about confrontation. That has nothing to do with the
Well,
people.
cross-examination.
So the rule is hearsay. Hearsay is different.
I hear you, but
If it's just, okay, if you showed it to him, that's fine. You could say, ladies and gentlemen of the jury, I showed him an email, and he said X, under oath. That's fine. Can you put the document in? No.
But well, the reason I'm asking is because it did go in front of the jury, and the jury saw it.
I excluded it. I have sustained the objection. The objection is sustained. You may not present evidence to which an objection has been sustained. I don't know, that's pretty fundamental. Mr.
I understand
Chair.
that, Judge. It's my recollection of it is different. My recollection is that the jury saw it, and it was not excluded from the jury seeing it while we were cross-examining.
Well, you're ahead that far, but you don't get to show it again just because you showed it to the jury before, and I sustained an objection to it saying, too late, Judge. They already saw it. I'm going to show it to them. I'm going to give them each a copy. They're going to take it back. I mean, it's excluded. I sustained the objection. If you would like a reconsideration, if you have some exception, you may argue that to me, but you've given me no authority why this is not hearsay. I've sustained the people's objection. You can't show things to the jury to which an objection has been sustained. That's about as simple and fundamental as it gets.
But you could have like a chart for demonstrative purposes that recites what the witness said in response to questions about it,
I
correct?
think so. And again, a reminder, please display your demonstrative evidence to each other. Not demonstrative evidence, demonstrative. Your graphics, anything that you're using as an aid to argument shall be shared. This is not, the rules are a little different from opening statement and argument. So argument, I do
And that's the defendant exhibits A1, the letter N, with the exception of the
Keep them on your
exhibit.
slides. You have PowerPoint slides?
A1E? No, or is
No, I'm
it
trying to,
exhibit
I
E?
don't have all of it. I only have
You don't have A1?
If you don't have
N.
PowerPoint,
This is exhibit E. They tell me it's E.
No, I have that.
Oh,
argue whatever.
Your Honor, I'm gonna, with your,
do you, I showed you verdict forms. Did you approve?
So they're not
Do you approve of the verdict form?
I wasn't, I didn't see it. Can we tell you in the morning?
Yeah.
Okay, and Your Honor,
Yeah.
Mr. Ray sent a few suggested additional instructions, and I've shared them with the people. Can I read them with you tonight?
Yes, I'll look at them quickly.
So, Your
I'll
Honor,
do a quick pass.
they decided not to call an expert, so now they're labeling Mr. Durst a person with developmental, cognitive, or mental disability. We're absolutely opposed to
Okay,
this.
let me look.
It's not even close.
Come on, John, right now.
Nope.
Okay, so I looked at 331, so Mr. Ray, on behalf of Mr. Durst, proposes 331. That does not apply to Mr. Durst. This is a person with a developmental delay. It helps the jury understand a cognitively impaired, developmentally disabled person doesn't testify in the same way. And it's important to tell them. That does not apply to Mr. Durst, who's quite sophisticated in his thinking, his answers, his thought process. So put this in as rejected.
Your Honor, just logistically, this can be off the record, but just logistically, I'm going to end up having to tell Mr. Jarecki that he is coming in to testify. If he is, does the court know when we will get the court's ruling?
I'm going to look at this. I was going to kick back and tonight and watch Ted Lasso, but now I'm going to read this and fret over it. And look up. I'll tell you in the morning. He's got to come in.
I want to meet the owner of the team, Your Honor.
Yeah.
Your Honor, if you by chance, whatever time, if you end up having a ruling and you're willing to tell us just, what it is, if you are, I'm just asking, I know Mr. Jarecki will appreciate it, his lawyers will, because I can let them know. If the court doesn't, then I understand, but if you happen to finish by midnight or
He's
1,
here, I take it.
That's a good question. I don't know if he's here. I think he must be
He looked
here.
like a motel room to me.
Oh, I didn't see, so I'm assuming he is here. I would doubt motel. Motel, I would say probably not. But I could be wrong.
All right, you can't unring the bell, but you can ring it twice. Department 1 is adjourned.
Your Honor, wasn't the Chez Marmont, was it?
Chateau Marmont.
Chateau Marmont.
Chateau Marmont?
You didn't see him at the Chateau
I know
Marmont.
one place he's not.
It's not the peninsula he's been banned